Shifflet, file 24-6855 FH. And Mr. Wood, like to know the status of this matter?
Your Honor, we have not reached resolution yet, though I am still hopeful. We would ask that the matter be put out for another docket call. And then, Your Honor, there was a weird snafu where Miss Shifflet was incarcerated in another facility at the time of her initial district court matters, and she was released from that facility without having been placed on bond here with Sheboygan. So I believe that we would ask that the court set a personal recognizance bond for Miss Shifflet. She has appeared. She's been talking to me. She's here ready to deal with this, Your Honor. I believe that the fact that she's here right now demonstrates that she's not a flight risk.
So is there an outstanding warrant for her and out of what court?
Your Honor, she was arraigned on April 26th of 2024 and a $10,000 cash surety bond was set by district court.
Okay, and then there was there's a bench warrant out of the district court for failing to post a bond. Well, this is tricky because the case has been bound over, but this is a warrant pre-bind over signed by. Is it pre-bind over? I mean, it's a warrant signed by the district court. So, I mean, I don't think I have the authority to do anything with that warrant right now. And didn't we mention this last time and told her to go down and take care of this?
And she has been trying, Your Honor. She has made arrangements with the bail bondsman. She is prepared to post bond today.
Okay, well, I mean, last time I didn't take her into custody. We said, go down to district court and deal with it. It's still outstanding today. She's going to be taken into custody right now. And then she'll have to deal with whatever, it's a district court warrant. It's not my warrant. So district court will do what they want to do with it. All right, but we'll come back August 20th at 10:50 a.m. on this case, okay? I mean, all those arguments you made are great arguments, but they'll have to be district court. File 24-6836 FH. Next, you want to state your appearances for the record?
Good morning, Your Honor. Paige Miller on behalf of people.
William Keough for Eric Ramirez.
Mr. Keough, we're here for sentencing on charges of fleeing, eluding third-degree habitual second and OWI third habitual second, both with 7.5-year maximums. Have you had a chance to review the report and recommendations, Mr. Ramirez?
I have, Your Honor. We have no objections to the narrative portion of the report.
The advisory guidelines were scored at 10 to 28 months and 0 to 21 months respectively on the two charges and the scoring challenges.
No, Your Honor.
Ms. Miller, any additions, corrections, or scoring challenges?
No, Your Honor.
And Mr. Keough, I did receive and review a copy of AA attendance log that you presented to this court as well. And with that, anything you want to say on behalf of your client?
Yes, Your Honor. Just briefly, Mr. Ramirez comes to the court as someone with a, I would say, relatively substantial history in regards to alcohol difficulties. And while he's had some prior treatment in this particular case, the sentencing agreement is for him to participate in the recovery court program. And he's taken it upon himself to be screened and to be admitted, and now he's here for sentencing. We have provided the court with that AA sheet that's been referenced, and he clearly is taking this very seriously and is being very proactive in this matter. He's just showed me an additional sheet. He's been going to AA meetings as recently as 2 days ago, and I think that from what I understand so far, he's doing very, very good job in the program. I anticipate that he's going to continue to excel in the program, and he's indicated to me that he's doing much better, not only with his addiction, but he's doing very well psychologically, and has real high spirits going forward. I just talked to his significant other who's here in the courtroom, and his mom seems to be very happy with how things are progressing. So with all that being said, we would ask that he be sentenced to the recovery court program. I thank the court.
Thank you. Mr. Ramirez, it's not required you say anything today, but it is allowed. Is there anything you want to tell me today? Or no?
I don't remember much from that night, but I do know the actions were not correct. They were stupid on my behalf. I could have endangered others or myself. Took up a lot of the court's time, so with that, I apologize.
Not could have, you did. I mean, I know personally law enforcement officers who've been seriously injured during exactly these types of situations. And I have known personally people who've injured themselves, and I've known personally people who've been injured, you know, that were innocent bystanders as well. So you could have injured them, but you did in fact place everybody at risk of injury. Ms. Miller, anything from the people?
Thank you, Your Honor. Mr. Ramirez is 39 years old. He does have 4 prior misdemeanor convictions and 1 prior felony. Significant to this case, he has a 2009 prior convictions of fleeing and living and impaired driving, as well as a 2018 conviction for operating while intoxicated. So this was a very significant event. When the defendant was operating his vehicle, when he saw law enforcement behind him, he sped away down a 2-track road. When law enforcement again was behind him, they initiated their lights and sirens. The defendant continued to speed away, traveling over 95 miles an hour, and at one point extinguished his lights. And then during the course of being pursued by law enforcement, he failed to make a turn and caused him to crash into trees and do some damage to a street sign and telephone pole. When the car was crashed, the defendant then exited the car and tried to run, but did fall and wasn't able to get away from the scene. When he was approached by law enforcement, there was blood on his face and his hand. He admitted to consuming alcohol. He needed medical attention, but was ultimately cleared the same day. And there was a vehicle fire as a result of the crash. So this was an extremely significant incident. It is clear from his history that it appears there is an ongoing issue with alcohol and substances. So I do think the sentence agreement to have Mr. Ramirez participate in and complete the recovery court program in this court is appropriate. So I would ask the court to follow that agreement. Thank you.
Okay, thank you. Well, Mr. Ramirez, you know, the advisory guidelines in this case are what's called a straddle cell, meaning you could get local jail time or probation or even prison. And given, even though this is what they call a true third, that this isn't a 4th or 5th offense, because we only count up to 3 in terms of the charge. It's OWI third, no matter how many you have. But this appears to be a true third with priors in 2009 and 2018. But there's a prior fleeing and eluding. And that plus the factors that the prosecutor outlined would mean, absent the recovery court program, I guess I just want you to understand, absent the recovery court program, today would be the day you'd be going to prison, for sure, in my mind. But I do think that that you are an appropriate candidate for the recovery court program, and you've been cooperative and compliant with that program and seem to be engaged with counseling. So I'm very hopeful. But you know, you don't want to become complacent. The disease of alcoholism is lying in wait there for you, ready to pounce, ready to take away everything that you have. So you've got to fight it with all that you have. I'm hopeful that you're going to do that. I have to make some statutory findings to place you in the program, and I do find, based upon the information presented to me in terms of the pre-sentence report, that this defendant is or was dependent on or abusing drugs or alcohol, but he's an appropriate candidate for participation in a treatment court program, that he understands the consequences of entering that treatment court program and has agreed to comply with its terms and requirements. I find that Mr. Ramirez is not a violent offender, and despite the fleeing and eluding convictions, based upon his compliance on bond and his regular attendance with AA, I do find that he is not an unwarranted or substantial risk to the safety of the public or any individual. So therefore, I find that he is an appropriate candidate for our recovery court program, and I would so sentence him. So, Mr. Ramirez, I'm going to place you on probation for 30 months on both charges, subject to the terms and conditions listed on the pre-sentence report, which really are subsumed in the idea of, comply with the recovery court program. But all those terms in the pre-sentence report do apply to your terms of probation, including some financial assessments, $130 to the Crime Victims Fund. There's a monthly supervision fee to the Department of Corrections. There's $350 in court costs, $459.48 as an OUIL reimbursement requested by the prosecution, $136 in state costs, a recovery court participation fee of $600. And also, it's not in the pre-sentence report, but I am going to assess what I believe to be a mandatory minimum fine of $500 on the DWI count. All right, and you're not subject to early discharge from probation, but what happens is the day that you graduate from the program is the day that we'll also discharge you from probation. All right, that's the sentence of the court, Mr. Ramirez. You may file an application to appeal if you wish. And if you wanted me to appoint a lawyer for you, I would do so, but you'd have to make that request within 42 days of today's date. We're going to hand you a copy of the appeal paperwork, ask you to initial one copy for us. The other one's for you to fill out if you wish to appeal. And we'll see you tomorrow for recovery court. Do you need to see him today, Mr. Fagan?
No, that's fine.
All right, we'll see you tomorrow morning for recovery.
Thanks, Tyler.
And Mr. Keogh, I'll tender back to you your client DA sheet in case you need to fill it.
Well, very good. Thank you. Thank you, Your Honor.
Oh, thank you. All people to Ryan King, 24-6822FH for an adjourned sentencing and bench warrant.
This is
Can you report anything about that?
Your Honor, Mr. King has been working diligently on it. It is not resolved just yet, but it is my understanding that he was going to be able to do that this week.
Okay. And I have been advised that there's been a new felony warrant issued for him out of Sheboygan County. And it apparently predates, it's not post plea, and it does even predate this offense date, but it is a valid warrant. So do you want to go forward with the sentencing now or wait and see what shakes out with it?
Your Honor, I would really rather be able to see what that new file is before we go forward with sentencing
I
today.
think that makes sense as well. So Mr. King, what we're going to do is adjourn your sentencing a little bit out here, because you're still sitting on a sentence agreement that you haven't done anything wrong since that agreement's been entered. But I want to see you take care of Isabella. We don't know what's going on with this new case. So we'll continue this to August 27th at 10:20 a.m. for sentencing.
I have been in communication with Isabella and they know my situation, so I am communicating with them.
And then you will be taken into custody right now on the outstanding Sheboygan warrant and arraigned in the district court in due order.
I did bring your drug test from the bond line as well.
Okay, we'll see you back for sentencing August 27th.